This is WEBN News, Frostproof Florida with a special report. A retired federal judge, Barbara Jones, submitted a report last Friday that discussed what she observed over the past 14 months as the financial monitor. In her letter, she identified that the Trump Organization, during the pendency of the litigation by New York Attorney General Letitia James, that the Trump Organization still had incomplete financial disclosures, inconsistent financial disclosures, and errors. And Judge Barbara Jones seemed to even point out that there may have been some phantom loans that were on the books at the Trump Organization, which didn't take place, like a $48 million or $50 million loan that apparently an entity controlled by Trump Unit Acquisitions made to Donald Trump, which on further diligence, Judge Jones determined didn't exist. I did a video on that to determine whether or not that could be an unlawful debt parking scheme. So now Donald Trump's lawyer, Cliff Robert, has sent a letter to Justice Arthur Engoron attacking the financial monitor. Very distinguished retired federal judge Barbara Jones. And in this letter to Justice Arthur Engoron, they attack Judge Barbara Jones. They're sending it to a judge, Judge Engoron, who they also attack. But in this letter, they really go after Judge Barbara Jones. They say that she lacks competency, casts serious doubt on the monitor's competency based on, they claim, the letter that she sent to Justice Arthur Engoron on Friday. They also compare her to Javert from Les Mis. I'm not making this up, folks. And they basically say in this letter, and this is what they accuse retired federal judge Barbara Jones of doing, that she just wants Donald Trump's money, so she wants to remain the financial monitor. She's already been paid, they say, about $2.6 or $2.8 million by the Trump Organization to perform her financial monitor services. And they claim that the reason that she's identifying these incomplete disclosures, inconsistent disclosures, and errors in the letter that she submitted on Friday is because she wants to give herself more employment by continuing to be a financial monitor over the Trump Organization. Just to be very clear, some of the most ridiculous possible to make. I know you know that already, but retired federal judge Barbara Jones is like one of the most in-demand retired federal judges for independent monitorships to serve as, an independent referees in cases. And so she could pretty much find employment at anywhere. She probably has a waiting list that goes longer than a year. But this is, in Trump's world, how they attack her. Notably, too, again, that this is written by Cliff Robert without Chris Keiss on there, Donald Trump's other lawyer. And I think that's notable because I think Chris Keiss perhaps didn't want to sign his name to this thing, because going after such a distinguished retired federal judge like Barbara Jones, I even think Chris Keiss thought was probably a step too far for him. Just take a look at this letter, January 29th, 2024. So first thing Donald Trump does on Monday is have his lawyer, Cliff Robert, attack the financial monitor, Judge Barbara Jones. Here's what it says. Dear Justice Engoron, as you are aware, this firm represents defendants Donald Trump Jr. and Eric Trump. Well, at least they start off with defendant versus what Alita Habba calls him. The January 26th report, referring to the Financial Monitor's report by Barbara Jones. The January 26th report, issued mere days before an expected decision, has only two obvious purposes. Just pause there. The obvious decision is the fact that Justice Arthur Engoron stated that he was going to make a ruling in this case before February. So that's why they're saying it's days before the ruling. But it wasn't like Judge Barbara Jones had nefarious timing. That's the whole reason that the report submitted is to assist Justice Arthur Engoron in his final decision, because one of the things that New York Attorney General Letitia James is requesting is a continued monitorship with even more robust powers for the monitor. So, of course, the monitor is going to submit a report before the decision is reached to determine whether that's one of the remedies that should take place. Justice Arthur and Gord requested the letter for that very purpose, but Trump's lawyer cast that as a very nefarious thing taking place. So it says, the January 26th report, issued mere days before an expected decision, has only two obvious purposes. One, to ensure the monitor continues to receive exorbitant fees in excess of $2.6 million to date. So pause there. So Trump has to pay the financial monitor. So Trump's paid the monitor to date $2.6 million over the 14-month period. And so here, Trump is accusing the financial monitor of being greedy of this report because she wants Trump's money. I'm sure that's going to go over real well. 2, fill the gaping hole in the Attorney General's case, namely that there is no basis to support continued oversight. The January 26 report also contains numerous factual inaccuracies, casting serious doubt on the monitor's competency, fails to reference governing standards of any kind, and is otherwise misleading and disingenuous. Indeed, despite having reviewed thousands of pages of financial data relative to more than 400 entities and having been paid millions for her oversight, the monitor points only to minor and immaterial discrepancies and simple math errors. For example, millions paid so the monitor can uncover 7 immaterial disclosures, 3 irrelevant, inconsistent, and 5 clerical errors. Pause right there. So ultimately, Trump, if that's what you feel, if you feel that the monitor didn't find anything serious, well, then why does a hit dog holler? Why are you sending this letter that's like 5 pages where you're editing the financial monitor if ultimately you found the financial monitor didn't find anything of substance? Wouldn't you just send a very short letter to Justice Arthur and Goran and say, hey, the financial monitor has only identified some immaterial errors. As a result, we agree with her report. We fixed those errors, and therefore there's no need for a financial monitor to continue. Wouldn't that be the approach if ultimately you say the financial monitor only found very immaterial and small mathematical errors? Oh, by the way, it should also be noted that Donald Trump's so-called experts, who Justice Arthur Agoran just absolutely eviscerated after they testified, their whole thing was when Donald Trump would engage in these large-scale fraudulent acts that are being alleged by New York Attorney Generals, by the New York Attorney General's office, that those are rounding errors, those were math errors. That was just a mistake. Everybody makes mistakes. That's one of the things that Trump's experts actually tried to argue. So you see Trump's pattern here. It goes on to say, the January 26th report by the Financial Monitor also contains numerous factual inaccuracies, casting serious doubt on the Financial Monitor's competency. So again, you see there again, they're attacking the Financial Monitor's intelligence, Judge Barbara Jones's intelligence, which a very distinguished retired federal judge, and Trump saying, no, I have all of the answers. I have all of the answers. Goes on to talk about the monitor issued 5 prior reports, specifically advising the court of defendants' ongoing cooperation and compliance. And now for the first time, it includes these self-serving statements. Self-serving statements. Again, these are serious accusations to be casting at Judge Barbara Jones. Goes on to say, however, the Trump entities cannot legitimately be held to a strict liability standard wherein immaterial inaccuracies or math errors form the basis for expensive and meaningless ongoing oversight. Further oversight is unwarranted and will only unjustly enrich the monitor as she engages in some Javert-like quest against the defendants. Again, comparing her to the character from Les Mis. Then it goes on, I'll just give you some examples where it says the purported incomplete disclosures that were identified by Judge Barbara Jones, the Financial Monitor. First, the monitor states that certain loans still require that defendants submit financial information fairly representing the financial condition of the guarantor in a manner consistent with the documents previously provided. and that in 2022, defendants elected to provide the trust material assets and material liabilities, which does not represent the financial condition of the guarantor or other financial information about the listed assets. However, as the court and monitor are aware, the statement of financial condition is no longer prepared. Instead, the Trump entities prepare the MAML, the material assets and material liabilities, which includes material debt of each property. The MAML has been provided by the Trump entities to certain lenders. No lender has raised an objection to receiving the MAML, and each lender has accepted it without incident. And so again, what Trump tries to do here is say that because of his bullying tactics, because of his threats, he's not going to submit the accurate documents that he's supposed to submit. He's not submitting statements of financial condition anymore. Why isn't he submitting them? Because now they're evidence at a trial which are demonstrating that he's engaged in fraudulent conduct. So instead, he's submitting these things called MAMLs, and he's like, well, as of now, no lender has yelled at us for doing that. So you, the retired federal judge financial monitor, stay out of it. Who cares if we're compliant with what our underlying agreements are? So that just gives you an example of what it is. The purported inconsistent disclosures, here's an example. First, the monitor states that expenses related to management fees for 40 Wall Street were inconsistently presented with annual budgets prepared and submitted to the lender when compared to the management fee recorded. Monitor is, of course, well aware expenses in a projected annual budget will, of course, differ from expenses in the actual final audited financial statements. As the monitor also knows, the actual management fees are based upon rent collected during the year, which cannot possibly be predicted with certainty when annual budgets are prepared. Well, if that's the case, then why don't you just tell that to the monitor? And then, this is not the first time anybody's, provided expenses like this before. So just share that with the monitor. And I'm sure if the monitor thought it was not a big deal, this retired federal judge would say that's consistent with normal business practices. But that's not what she did. And then it goes on to discuss the purported errors. And it talks about how, I'll give you one example of purported errors. First, the monitor states that management fees were erroneously excluded from the calculation of loss after management fee expense, CapEx, TI, leasing, mortgage payable in the 2024 final 40 Wall Street budget. It goes on to say, in other words, this is how Trump says, this was simply a clerical error caused by cutting and pasting from the Microsoft Excel file. The underlying income and expense line items shown on the schedule were always properly disclosed. So there's just a copy, millions of dollars, just a copy and paste error from an Excel spreadsheet in a company that's accused of systemic fraud over and over again. Spreadsheet error, folks, spreadsheet error. And then this is the conclusion letter to Goran. As noted above, the monitor has thus far been paid over $2.6 million in the past 14 months to uncover 7 immaterial disclosure items, 3 irrelevant inconsistencies, and 5 clerical errors. Now, after representing that the defendants were fully cooperative and compliant, the monitor desperately seeks to justify the continued receipt of millions of dollars in fees going forward, setting aside her self-serving hyperbole. Her hyperbole, reading this, there's nothing hyperbolic in her letter. This is hyperbole. Her letter was a very kind of just surgical point. There was no hyperbole in her letter. It's all projection with Trump and these people. Self-serving hyperbole. The monitor's own findings simply do not support providing any evidentiary basis for continued oversight. Then it goes on to say the court therefore must and should end this abusive and costly process. Should the court have any questions, please feel free to contact me. Clifford Robert, and note again, Chris Keiss is not included.